Welcome. It is time once again for CU Immigration Forum here on WRFU LP, Urbana, 104.5 FM. I will be your host for this evening. My name is Mr. Garza, and I'm here to let you know that WRFU is an open forum for the Urbana-Champaign community. I would like you to understand that views expressed are those of the speakers, and further, those views are not intended to represent WRFU, UC, IMC, or the Urbana Socialist Forum, or, as we like to say on the TV version of the show, UPTV. Excuse me. These views are our own, and by our, in this instance, I mean myself and my charming guest, who will introduce himself as we speak.
Hello, I'm Jack Wilkie.
You are, aren't you?
I think so.
What do you do, Mr. Wilkie?
I'm a lawyer here in Champaign-Urbana, and practicing in immigration and other areas, but I work with a lot of Spanish-speaking clients.
Bienvenidos.
Muchas gracias, senor.
Turn this up a little bit so I can hear. Yeah. Sorry, I'm coughing a lot lately. So you work in immigration law.
Right.
Is that, that's not the only thing you do, right? I mean, you do whatever. If I broke my leg at work or ran into somebody, I could come to you and
I could do that. I don't do family law. I'm just don't like to fight quite that much.
Family law being like divorce? Is
right.
that pretty much what family law is? Or
yes.
Inheritance, I guess, would be something?
Well, no, I was referring more to divorce. I used to do that, but I figured out I hated it so much I decided not to. But because those are the clients that generally want to kill their lawyers. But I'm digressing a little bit. They
want to kill each other too.
That's true.
A lot of the time.
Yeah. But what I do is I practice in immigration law. I do criminal defense, traffic court. I do some workers' comp and personal injury. But immigration is probably more of the specialty because there's a lot of lawyers here locally, but probably only about a handful in Champaign-Urbana that do immigration law.
So here's something. I've heard many lawyers say this over the years, and I guess let me see if I understand it. So when you say I do immigration law, that just means you have been trained to do law with a capital L, but you mostly do you mostly handle cases in this general area. Therefore, you consider yourself sort of an expert in this area or something like that. I'm all tangled up here.
Well, yeah, although the more I do this, the less I know in some ways, it seems. But everything's getting more specialized, and immigration law itself has many different facets, and I only practice in a subset of them. So kind of like with beer, you have ales and lagers. There's that big dichotomy. In immigration law, there's employment-based law and there's family-based. And in both cases, the goal most people have is to get their green card, to get permanent residency. They want to be able to stay here in the United States, and they want to be able to work, and they don't want to have to worry about getting deported. Right. The two main mechanisms for attaining that are either a family-based petition. There's various close relationships where a family member can petition for you, or else there's also employment-based. I really don't do any employment-based, but pretty much exclusively family-based.
So employment-based would be, I have my own business. I own this radio station, let's say, for the sake of argument. And I would like to hire somebody, but the only person I can find, or the best person that I think for the job, is my friend so-and-so from country X. So I could sponsor this person and bring them here and say, I want to hire this person. He's the only person that can do this job. And the government goes, oh, all right then.
That's correct, I think, with the proviso that I don't really practice the area.
Right.
But yes, the boss, the employer, brings this person in. The little that I do know about it is that there's different types of work. So, for example, migrant workers, that's a certain type of H visa, and don't ask me what, H2 I think. But basically those are people who are brought in to do farm type work on a seasonal basis.
Yeah.
Then there are more professional type jobs, for lack of a better word. There's something called an H-1B visa, which basically is a job that would normally require a 4-year college degree or experience consistent with that, and the employer has to show that, you know, it's not a file clerk, somebody who's sharpening pencils. It's something like an engineer or something like that. And there's also more arcane specialty things, like, I suppose this guy is an expert chef from Guatemala and only he can make this type of food. So yes, that's the idea, but generally you do have to show that the prospective employee has certain qualifications.
So unique skills.
Right.
Of some sort. So a family thing would be more like my brother who lives in Cancun.
That's correct.
I think he wants to come here. We've missed each other. You know, I would like to sponsor him, or however that works, and I'll take care of him if he can't get a job or whatever, but I really want him here, kind of thing.
Yeah, that's the idea. And there's kind of a dichotomy in the family arena between what's known as immediate relatives and other degrees of kinship.
All right.
So an immediate relative would be the spouse of a United States citizen, the minor child of a United States citizen, or parent of an adult United States citizens. And for those family-based categories, there's an unlimited number of immigrant visas, which basically means there's not a long waiting list. So let's say I file for my wife from the Philippines. It might take a year, it might take 6 months to a year, but there's not like a 20-year backlog. For example, my brother from the Philippines, I'm a U.S. citizen, or my brother from Mexico. It depends on the country, but in the sibling category, you can have backlogs from, well, for example, I brought my little cheat sheet here. There's something called the Visa Bulletin here, folks, where you can look this stuff up. But so, for example, if you're talking about a sibling, for the Philippines, they are now processing petitions from September 1991.
Whoa.
Okay? That's 25 years ago, and they don't necessarily go year to year. They may get through 6 months of petitions in 1 year. I mean, the big countries are China, India, Mexico, and the Philippines. Mexico, it's not quite as long. It's June of 1997. India is May of 2002. So
wow,
these preference categories, there's a limited number of visas every year, so therefore there's a backlog. They only let maybe, for example, 10,000 people in per year in that relationship. So also, for example, the spouse of a permanent resident would be in the preference system. So but and it can't be any degree of kinship. So, for example, you can't apply for your cousin, okay? You can't apply for your uncle or your nephew. It's basically minor children, adult children, parents, and spouses. And the person who applies for them has to be either a U.S. citizen or, in some cases, a permanent resident.
So that sort of goes so far as to explain why people say the system is broken in a way, because assuming there are lots of people in these categories, like 1992, did you say? 91? That's
right. Yeah, that's a long time.
That's a long time.
And you could see why, you know, I mean, obviously it's a little harder to come in sin inspección from the Philippines because you got a big ocean, but that,
right.
You know, there's economic necessity at work here, and you have a lot of people coming from Mexico, and I think eventually one of the things the government is going to need to do is to increase the number of immigrant visas. I mean, if they want to give people an incentive to come here legally, I think they're going to have to do something to shorten the waiting periods here. If they increase the number of visas that are available, then perhaps this backlog could be gotten through quicker. So, yeah, that's how the family-based system works. And one of the big dichotomies within that group is the process that you go through if you've come in with a visa or if you came in basically undocumented. It makes a big difference.
So you've got all these people wanting to come here, and some of them, for reasons of their own, say, you know, I can't wait 10 years. I just can't wait 10 years. You know, it's ridiculous. I've got to go now. I've got a job now. My friend in the States says, hey, we're hiring right now, and we're paying $15 an hour. And I'm sitting here going, I make a dollar a day. I got to do this, you know. You come in under the radar, however you get here. That's probably where your problems begin and where you run into a lot of people who have done that. Probably more of those than, let's say, I'm guessing, than the people who have the wait and come here and then just, you know, going through the process kind of thing.
I think that is true. I mean, it does depend on where they come from. But, I mean, here in Champaign-Urbana, we have kind of a unique, we have both situations. So, you know, obviously with the University of Illinois, you have people from all over the world who have come here legally because they're here on student visas, okay? And that's one facet of my practice. So somebody comes from China or India or South America or wherever, they come here on a student visa, and eventually they get married to a United States citizen. Those are the easy cases from an immigration law standpoint, because as long as that person could show they were lawfully admitted to the United States, as long as they can show that it used to be an I-94 stamp in their passport, now it's electronic, but as long as they could show that they were inspected at the airport, it doesn't matter if they overstayed their authorized 3-month or 6-month stay. I mean, with a student, it's usually duration of status, but let's say somebody came in on a tourist visa. Typically, the visa itself is good for 10 years, but the authorized stay in the United States is typically 3 months or 6 months. Let's say they came in 1999, they can show they were lawfully admitted. In 2015, they get married to a U.S. citizen. In that context, if the person that's filing for them is an immediate relative, maybe not a sibling, but an immediate relative, immigration will forgive that gap in their status, and they can do what's known as adjust status. That's the immigration lingo for getting your green card while you're here in the United States. And it's a pretty easy process. I mean, there's certain prerequisites, but basically you're adjusting your status from what you were, student visa, visitor visa, to permanent resident. You don't have to leave the country. You don't. On the other hand, the other side of the coin here in Champaign-Urbana is a lot of my clients are from Mexico or Guatemala. Okay? Most of those people are undocumented, and that's the other side of the coin here. And so to get back to your question, yes, most of those people from those countries are here without a visa. Okay, I mean, my understanding is it's very difficult to get a tourist visa from Mexico, if not impossible. So, I mean, some of them are here on student visas, but most of them are undocumented. Now, that situation is the more difficult because if they, let's say they marry a U.S. citizen, let's say a man from Mexico marries a woman who's a United States citizen, the good news is there's no waiting period. They're an immediate relative. But the difficulty is that, excuse me, because that person entered sin inspección, without inspection, without a visa, eventually they're going to have to leave the country and knock on the door at the consulate in Ciudad Juarez because they didn't enter with a visa. Once they leave the United States after being here more than a year undocumented, they trigger a 10-year reentry bar. They have to leave the country now, okay? But once they leave, the law is you have to wait outside the country for 10 years, which is obviously an untenable situation for families. You know, a lot of these people have children together. In that context, however, you can apply for a waiver, okay, a hardship waiver. The issue is you have to show that the U.S. citizen spouse would suffer extreme hardship if either her husband she was separated for 10 years, or if she had to go to Mexico. Those cases are harder.
Yeah.
You know, it's not a sure thing. There's some trauma and drama, but, you know, I've had some success, but it's certainly a different procedure.
Wow, that's really strange. So let me see if I understand this. So if you're here as a student, say in 1991, we'll use that as an arbitrary year, and then you just kind of stayed, you didn't really leave, you were technically undocumented.
Right.
But you had that original visa, so after all those years go by, then you get married to a U.S. citizen, then you apply it, then they just go, oh, well, all right, that's fine, we'll
let you do it all
paperwork,
here in the United States.
and you're fine.
Easier.
But if you came here as an undocumented person, same thing, 1991, get married, apply, then you're supposed to leave and stay gone for 10 years before they even consider you coming back. It's not like 10 years and you're a sure thing. It's 10 years and then we'll decide.
Right. Because one of the prerequisites to adjusting your status that you were, quote, lawfully admitted, past tense, to the United States. So maybe that admission occurred in 1991, but that's the legal basis for that. And yeah, I mean, it's a huge difference in what you have to go through, because and the other potential issues. So you apply for a waiver, and to be honest with you, if you have children in common, or let's say the U.S. citizen spouse has some health issues, for example, where they need to visit the doctor here in the United States, if they had to go to Mexico, that would be a hardship because I couldn't get the medical care there. Or if one of our kids has some medical condition, indirectly, that's a hardship to the U.S. citizen spouse. Or, you know, and these are the best case or the best proof for a waiver. Or let's say I have an elderly parent who relies on me as a caregiver. If I have to go to Mexico and leave that person here, that's hardship. So that's the difference, and you know, you're dealing with different consulates too. I mean, most people here it's Mexico, but and the other issues are if people have problems with the law, and I practice criminal defense, and to some extent DUIs can be an issue. That can be an initial basis for not being able to get your green card in the United States, and you know, having to go through the consulate and apply for a waiver. And it depends on the crime. If you have a felony, you know, there's felonies and there's misdemeanors in criminal law. A misdemeanor is you can get up to a year in the county jail. That's the maximum. A felony, you can be sent to the Department of Corrections prison. That's the dichotomy there. Most felonies are a real, in most cases, insurmountable problem for somebody who's trying to get a green card. You know, misdemeanors, not so much. It depends on the sentence, but that could be another. So, for example, a person could be here with a visa and married a U.S. citizen, but let's say they had a couple of misdemeanors on their record. They're probably going to have to go the route where they leave the U.S. and apply for a waiver, because those criminal law problems are an additional impediment along with the you know, the illegal presence here. There's a timing issue, though. If you're in the United States less than 6 months and you leave the country, let's say you snuck into the country and you leave 5 months and 28 days after you got in here. As long as you haven't accrued more than 6 months of illegal presence, you don't trigger any reentry bar. If you're here from 6 months to a year and then you leave, you trigger a 3-year reentry bar. But once it's over a year and you leave, then it's the 10-year reentry bar. So,
gosh, this is getting
get out while you can.
Yeah, this is getting complicated. Okay, so let's jump back. Something came to mind, and I'm just curious about it. So, let's say you were 14 in 1991 when your parents brought you here. You had no choice. Entered illegally, no paper, no documents, no nothing. Then you grow up, go to school, marry a U.S. citizen, then you applied. Does that make any difference, or are you still just as bad as if you came across the border?
Not necessarily. I mean, there's some relief that would be available to younger people. So, let's say
because you're an adult now, This is 1991. So
right. Okay. Well, let's back up for a little bit. Let's just assume that this person came to the United States in 2011, okay, when they were 14 years old, okay? As long as they leave the United States before they turn 18, then their legal presence is not held against them. So they don't trigger a reentry bar. So if that person could go back to Mexico, for example, before they turned 18, they could have lived here in their whole life in the United States for 18 years. As long as they leave before they're 18, they're okay. Now, going back to your example about 1991, there's the relatively recent DACA program, which is available to younger people, which is something. It's certainly not permanent residence, but basically, and there was an attempted extension that is being fought in the courts now, but the original program is still in place. So if you can demonstrate that you came to the United States before you turned 16, and if you can demonstrate that you came to the United States before June 15th, 2007, and if you can demonstrate that you're either in school now or you graduated from high school here in the United States, or even, and in school has a pretty broad definition. So if you're taking English as a second language courses at Urbana Adult Education, and that's meant to lead to a GED, I think that could be defined as in school. Or if you're in the military, even if you're not in school, people in that situation can get, and also you don't have a DUI, and the only brush with the law you've had are relatively minor misdemeanors. That person could get what's known as deferred action, and this is a program that's been around since 2012, and basically, and the other thing is the person has to be born after June 15th, 1981. Okay, the extension of the program has an unlimited age cap, but this is basically for younger people who were born after that time. You get a period of 2 years where basically the government says, we're going to leave you alone. You're kind of in a limbo. It's not permanent residency, it's not citizenship, but you can get a work authorization, okay, and you can get a Social Security number, so at least you can work during this time period. Now, leaving the country and getting back in, that's problematic. That it's possible. I really haven't looked into that a lot, but just because you get the younger person gets deferred action and the work permit doesn't necessarily mean that they're going to be able to. I mean, anybody can leave the country. The real issue is getting back in. So that is available to younger people who are in school, and there's been the attempted extension that Obama announced last November would, as far as the younger people goes, first of all, it would remove the age cap. I think you can be here, you don't have to have been here since 2007. You could be here since January 1, 2010. You could be a more recent arrival. You don't have to be, you can be an older person, and it was for a 3-year period. And there was another program for parents of U.S. citizen children or parents of permanent resident children who were born before November of 2014. These parents, if they didn't have criminal law problems or DUIs, were supposed to be able to get the same type of relief. But both of those programs announced last November are being challenged in the federal courts now, so we don't really know what's going to happen with those.
So both of them are on hold. They can't do anything about that.
Well, I mean, younger people are still eligible to apply for the original program of DACA, as long as they meet the original requirements, as long as they were born after June of 81 and have been here since 2007 and can show they've been at school. They can still the Immigration Forum, of which both of us are members, as you know, has helped a lot of young people. And some people, you do have to be 15 years old to apply for this program. So some of these kids who have just turned 15 are now coming in. They could still get that original 2-year DACA if they otherwise qualify.
And can they reapply? The ones who had it before, can they reapply now? That's not on hold?
No, as long as they were approved under the original program, they can reapply. I've helped several people reapply. It's not for 3 years, it's for 2 years. And that's a fairly easy process because you don't have to show all the school records to show that you've been here. If you were approved at the beginning, basically you just have to show that you haven't had any problems with the criminal law in the meantime. You can renew fairly easily.
That's good, because I wasn't clear about whether it was all on hold or whether the original was up and the renewals are on hold. You know, it's
kind of confusing.
When you read the news, it's a little vague, you know, as to. So it's just basically his new proposal, the expansion of DACA, for with the removal of the age limit, and then the one for the parents. That's what's on hold right now.
People can get their first DACA under the old rules, and they can renew DACAs under the old rules, but it's just the new expanded version is on hold.
And I'm sure a lot of young people are very confused as to what they can and can't do right now.
Yeah, I mean, there's a network out there on the street, and there's a lot of bad information out there. Make sure you consult an attorney.
Yeah.
But, yeah, you know, and unfortunately, there's unscrupulous people out there. Some of them are lawyers, believe it or not, but or notarios or whatever. But it's really not that complicated. But you just need to talk to somebody who knows the guidelines.
Yeah, well, I mean, I probably know more than your average person, and I wasn't really that clear about it myself. So, you know, I'm sure just the person on the street is probably really confused. They just, oh, it's on hold. What does that mean? Does that mean, you know, I've got DACA? Does that mean I no longer have it? You know, what is,
right. Well, I mean, and there was always a concern about, okay, I'm undocumented. I don't really want to be sharing all this information with the government. I mean, at the beginning, there was a big thing about, is this just some big trap? Is this a dragnet? Am I going to give all this personal information to the government? And you know, the guidelines specifically say, unless you actually tell us you've committed some really bad crimes, and you shouldn't be applying for this if you have those on your record anyway. I mean, that would make no sense. You're not going to qualify. We, immigration, will not be sharing this information with ICE, just because the whole idea of this is to benefit undocumented younger people who have basically stayed out of trouble. So, but I think there was, at least initially, some reluctance to participate in this program because people were reluctant to share this information. And now that there's a track record, now that people have gotten DACA and, you know, there's been some benefits to it and some have been able to renew it, and hopefully some of the younger people will be forthcoming and apply. Yeah.
Well, I hate to say it, but as far as the TV version of this show is, we're done. And
bye, everybody.
We're out of time. So if you'd like to stick, we can talk about what happens next week later. But anyway, thank you so much for coming to the show.
Thank you for having me.
You have been listening to CU Immigration here on WRFU LP and UPTV. I hope you'll join us next time. See you later. Bye-bye.